For the first time in history, African Chief Justices have come together to discuss alternative dispute resolution as a critical thing to embrace in a bid to reinstate the African traditional way of resolving disputes. The judges are holding a two-day meeting in Kampala.
Riches of creation are shared.
In their deliberations, the continent's judiciary chiefs emphasized the need to relax laws that were adopted from colonial masters and realign to the pre-colonial dispute resolution mechanisms such as mediation, arbitration, negotiation, and conciliation. According to the judiciary, a large portion of the Ugandan population has stopped seeking justice from the formal court system as it takes too long to resolve matters. The case backlog in Uganda currently stands at about 42,000. Now, these are cases that are pending before the courts of law for a much longer time than that prescribed. The Chief Justice Alphonse Oyinyidolo says it is extremely difficult to handle all these cases because there are very few judicial officers in the country.
The primary object of ADR movement is avoidance of vexation, expense, and delay, and promotion of the ideal of access to justice for all. The ADR system seeks to provide cheap, simple, quick, and accessible justice. So precisely saying, ADR aims at providing justice that not only resolves dispute but also harmonizes the relationship of the parties.
Uganda is a heterogeneous state, and different tribes had different ways of resolving disputes in the traditional African setting. So how exactly is judiciary going to promote ADR in such conditions?
The judiciary is going to do the training, ensuring that judicial officers appreciate it well and are able to embrace it and advise parties accordingly. Then, of course, also train the mediators out there who will be court-accredited mediators. We are targeting retired judicial officers.
He says the alternative dispute resolution can be applied in all types of offences, but should the parties involved fail to mediate, then the matter can be taken up by the courts of law. Part of the judiciary's budget is already facilitating the alternative dispute resolution in the country. However, the Chief Justice says there's need for more funds.
I am happy that our judiciaries are realigning themselves to their African roots. The pre-colonial methods of handling disputes must be studied, and they have some positive elements within them that the present legal system must emulate. Government of Uganda will support the judiciary to expand the use of alternative dispute resolution. This will help to rejuvenate the traditional systems of dispute resolution.
During the last financial year, judiciary mediated to conclusion 1,250 cases under the mediation scheme. 22,092 cases were concluded under small claims procedure, while 2,857 criminal cases were completed under the plea bargaining scheme at the High Court level, and 2,389 others in the various magistrates' areas. DANIEL KIBET, NTV Tonight.